Hello everyone. While we all are celebrating landmark Supreme Court judgment in the case of Mohit Minerals on levy of GST on ocean freight services under CIF contracts, on the same day we witnessed another Supreme Court judgment in the case of Northern Operating Systems, wherein the Supreme Court has unsettled a settled issue on levy of service tax on secondment of employees. So in this video, we will be discussing the facts of the case and what Supreme Court held and what is our take on the judgment. So starting with the facts of the case, there were two agreements between the Indian entity and the foreign entity. In the first agreement, Indian entity was providing back office support to the foreign entity and was receiving consideration based on costless markup basis. In the second agreement, the foreign entity was sending employees to Indian entity on secondment basis for a particular period of time. Now, as per the scope of the agreement, following clauses were appearing. The seconded employees will remain to be on the payroll of the foreign entity for the purposes of social security benefits and retirement benefits. However, for all practical purposes, Indian entity will be the employer of the seconded employees. Secondly, employer's remuneration was determined in foreign currency. Thirdly, foreign entity will remunerate employees its basic salary, bonus, social benefits, and other expenses, and will take reimbursement from Indian entity on actual basis. The control and supervision will remain that of Indian entity. That is, the employees will work under the instructions and directions of Indian entity. The agreement specifically provided that terms and conditions of employment of foreign entity will cease during this period when employees are seconded to Indian entity, and all the terms and conditions as applicable between Indian entity and its employees will come into the picture, and that will enforce seconded employees. Lastly, the agreement provided that the role of foreign entity during the secondment period will be limited to that of payroll service provider only. So this is an important fact that the agreement itself provided that the role of foreign entity would be that of payroll service provider and not of that of employer. So coming to Supreme Court's judgment, the Supreme Court observed following. The first was with respect to direction and control test. So if we see all these judgments prior to this judgment, whether it's Volkswagen or computer science, in all these judgments, the courts have held direction and control test as the relevant test to determine as to who acts as the employer of the employee. In this case, the Supreme Court disregarded this concept and said that direction and control test is irrelevant and not a single determinative factor, and multiple factors would be relevant. While the Supreme Court noted that Indian entity had operational and functional control over the employees, at the same time, it held that it was only for the purpose of getting the tasks performed from the employees. Thirdly, the court observed that terms of employment remained to be that of foreign entity even during secondment. Next, the court observed that foreign entity in relation to its business deploys employees at Indian entity, and therefore it is for its own business that it is deploying employees at Indian entity and not for Indian entity's business. Upon end of secondment period, employees will return to foreign entity for second deployment. The court also observed that there is an existence of quid pro quo between foreign entity and Indian entity, as Indian entity is getting benefit of exports and highly skilled employees from the foreign entity. Lastly, the Supreme Court disregarded the earlier judicial precedent on the issue, calling it to be unreasoned and therefore having no precedential value. So, basis these observations, the Supreme Court held that service tax under reverse charge is leviable on this transaction, as the foreign entity is providing manpower supply service to the Indian entity. The court also disregarded the revenue neutrality argument, basis the point that it is only posed with the question of taxability of transaction and subsequent revenue neutrality is irrelevant. Lastly, the court held that extended period cannot be invoked as assessee acted in a bona fide manner when it relied on the earlier judicial precedent to take a call of not paying service tax on the issue. Now coming to the analysis of the judgment and our take on the same. In our view, this entire issue is very fact specific, and therefore this judgment will also be applicable on the peculiar facts of this case and can be distinguished based on the agreement terms and the factual implementation. On merits as well, we feel the judgment is incorrect for multiple reasons. Firstly, it disregarded the control that Indian entity was exercising over employees as an employer. Secondly, it was also undertaking compliances under income tax laws with respect to employees like deduction of TDS, etc., which is only done by the employer. Secondly, the court also did not acknowledge the concept of dual or joint employment, which is a well-settled concept and is also acknowledged in the draft circular issued under service tax. Lastly, the argument of revenue neutrality has also been incorrectly rejected. In respect of extended period, the judgment is correct, as it has rightly said that assessee believed on the available judicial precedent and therefore extended period cannot be invoked. In our view, clearly service tax is not applicable in case of secondment of employees where Indian entity qualifies to be the employer of the seconded employees. We believe CBIC may come up with a circular or an instruction to clarify this issue, as we have already witnessed in past in case of Ultratech as well as Westinghouse, wherein the Supreme Court held something and the circulars were issued later on that the judgments are fact specific and will not be relevant for deciding all the cases on this issue. Now coming to way forward as to what taxpayers need to actually do after the Supreme Court's judgment. With respect to service tax, most of the period has already become time barred, and a limited period of 3 months, that is April to June 2017, is the period where authorities can issue show cause notice, but that too after invoking extended period. And as we have seen that Supreme Court has held that in this case, extended period cannot be invoked. So to that extent, no new proceedings can be initiated under service tax. However, this issue is equally relevant under GST. So taxpayers need to reanalyze their agreements with respect to this judgment and should analyze whether GST liability under reverse charge needs to be paid or not. For the taxpayers who are eligible to avail ITC and there is no ITC accumulation issue, they may consider paying GST under protest. Second question would be the valuation, whether they can adopt the valuation under second proviso to Rule 28 or not. For future, taxpayers may consider paying GST under reverse charge, again, if ITC is available and there is no ITC accumulation issue. For the taxpayers who are engaged in exempt business or have ITC accumulation issue, it is suggested that they represent the matter and get a clarification from CBIC. Lastly, the transaction will have an equal impact on the income tax laws. Therefore, taxpayers must analyze the transaction from that perspective as well. With this, we come to an end of this video. Stay tuned for more videos. Thank you.